corpus to get the person released. Sometimes the minute you file a writ of habeas corpus, then the jail's on the phone to ICE. Oh, the lawyer filed a writ of habeas corpus, and then they come all the quicker and pick the person up. So it can be a nerve-wracking game trying to get the person released before they're picked up. So anyway, that's the kind of thing you were seeing. By the summer of 2011, however, the Obama administration started backing up on this very zealous program to deport people who had been picked up in the criminal system. So they started, at least stating they were going to concentrate more on the high-level offenders. And then a couple of different things happened. In June of 2012, the Obama administration announced deferred action for childhood arrivals. Deferred action is something that's been around for a long time. It's generally a form of prosecutorial discretion for people who are in removal proceedings or deportation proceedings. But the Obama administration extended this to people who were not in removal proceedings who met the criteria of the proposed DREAM Act. What this consisted of in terms of its criteria was if the person was under 31 as of June 15th, 2012, had entered the United States prior to their 16th birthday, had continuously resided in the United States since June 15th of 2007, was physically present in the United States on June 15th of 2012. They had either graduated from high school, were in school, had been honorably discharged from the armed forces, or obtained or were in a GED program. You had to be 15 years old to take advantage of it unless you were in deportation proceedings, and then that age did not matter. Well, that's been a marvelous thing for a lot of young people. It's helped them get work authorization. It's not lawful permanent resident status, it's not citizenship, but it does allow the person to get work authorization and they are not targeted for deportation. With the work authorization, then you can get a valid social security number, and at least in most states, and Wisconsin's included, you can get a driver's license if you're otherwise eligible, and you can live a fairly normal life here in the United States. So this has helped a lot of young people. I've done a number of these cases, and it's a pleasure to do them. I had a young guy whose case was delayed. Sometimes things just happen with the immigration service for no fault of anyone's that delay things, and we were able to call him up last week and tell him we got the approval, and he was just yelling and crying for several minutes on the phone. It was just amazing. I mean, things we take as citizens for granted, those rights, to even have some of those rights for the young people who really haven't known any other life but living here in the States is just heartwarming to see. So I've been very enthused with that program. The other thing that the Obama administration has done to sort of soften this secure community's impact is they've exercised a heightened standard of prosecutorial discretion in the deportation cases themselves, the cases that are actually in the immigration courts. So they have, that's been a little bit more difficult. They have criteria that they follow. They're pretty restrictive on the criteria. It's been a little bit disappointing. I think they're pretty strict on it, and we've seen some good decisions on that, but a lot of them, seem to be pretty narrow. It certainly helped some people, and at least gives people who don't otherwise qualify for relief in the immigration court a way to go, where they can at least seek that. Factors that they consider are length of time in the United States, if you have children here, other family connections, physical or mental hardship. Children are a big one, where there are custody issues, and also, if you have a criminal record, that's going to hurt. So those are kind of the factors they're looking at, but that has somewhat slowed down this huge movement toward deportation. So at least those are some encouraging things. The other thing that the administration has done in terms of something that they've done without Congress's consent is they've changed the procedure for waivers, the people who need waivers for unlawful presence here in the United States. They've allowed at least the spouses of United States citizens to do their waiver process here in the United States without having to depart the United States for long periods of time, which had been the procedure previously. I guess one of the things that I do a lot of, my background is really doing deportation defense work. And when I worked at National Immigrant Justice Center, I worked with what was called the Detained Alien Project. These were cases where people oftentimes had criminal records or were security risks, some of the more difficult cases. And we did that every day. You'd work on bond issues, you'd work on cases that were extremely difficult, trying to find ways to get relief for people where the cases were very difficult. And I think that's given me a great appreciation for the struggles that people have in the immigration system, being detained for long periods of time, oftentimes not having access to criminal counsel or to defense counsel, and dealing with just a difficult system that's often complex and confusing in terms of dealing with the complexities of the law. I think another thing that people don't really realize is the tremendous backlogs for visas. The backlogs, really there hasn't been a change in the amount of visas available, meaning the amount of people who can obtain papers here in the United States. Since 1978, the number is about 290,000. And the demand, as you might imagine with the numbers we've been describing, causes huge backlogs in that seeking of the visa. There are backlogs of 20, 25 years for people who are eligible for lawful permanent resident status, but because of the backlog, the demand versus the amount of visas that are available has just made it virtually unrealistic for many people to get status here through the lawful system. So, one of the things that the Senate bill would do is eliminate that backlog that would allow a number of people who are eligible to get status here in the United States to get that status without the huge delays that are currently locked into the system. Basically, from a family-based system, you're probably wondering kind of what I'm talking about here, I would guess. When you're talking about getting the residence, there's basically three ways you can do it. Family-based petitions, employment-based, or you can have an asylum or refugee type of situation, where you're coming from a country due to difficult country conditions that are either brought on by the government or it's something that the government is unable to control.